So the video you're about to watch is the ATF's training that they trained all of us federal firearms licensed dealers how to recognize, understand, and what to do with any of these pistol braces that are now banned as of January 31st. You're going to notice the first 20 minutes is the ATF's training. The next hour are the questions that all 600 of us FFLs had for them. Take a look. Take notes, and then join Gun Owners of America to make sure that they are protecting your rights. They're the only no-compromise gun lobby in Washington fighting for yours and my rights.
Depending on questions. The PowerPoint that we are going to review with you today is posted on our public website. We will show you the link. It's at the end of the PowerPoint, but you can simply go to atf.gov, and in the search bar, you could type in stabilizing braces. You will be able to get to the webpage that has all the information about stabilizing braces, including this PowerPoint, as well as some frequently asked questions, most of which were asked during our first session at 10 a.m. this morning. So it is a great resource. I really encourage you to go there. There will also be some email addresses that we show you at the end if you have any additional questions. Again, I can't turn on audio because at this point we have about 650 people in this training, so it would be a bit chaotic to turn on everyone's microphone. So please use the chat or the Q&A box to type in your question. You can certainly type your questions in right now. However, I would encourage you to maybe wait until we get through the presentation, because most of the questions that I'm already seeing in the Q&A are going to be answered as we go through this presentation. But again, that is up to you to communicate with us. Just use that Q&A or the chat box. All right, let's go ahead and get started.
Okay, so we're going to start the presentation with a little background as to how we got where we are today. So on November 8th of 2012, an FFL submitted the first stabilizing brace prototype to ATF, which was a brace that attaches to a heavy AR-type pistol. The brace would rest on the forearm and could be fastened with a strap. According to the submitter, the purpose of the brace at the time was to provide security for disabled shooters or anyone else who did not have the physical strength to accurately shoot a heavy pistol. The submission was to get a determination as to whether the device, when attached to a pistol, would change the firearm classification from pistol to something else under federal law. Based on the information provided, ATF inspected the brace device and found that that particular prototype, when attached to a firearm, did not result in a firearm designed or intended to be fired from the shoulder. Since that time, the firearms industry has been flooded with so-called stabilizing braces that no longer resemble the original prototype. And most of them have been marketed and sold as shouldering devices when attached to a firearm. So for the entire background, you may go to section 2B of the preamble of the final rule, and it gives the entire background and history of how we got to where we are today. So this slide shows a photo of the original submission, and as you can see, it was it attaches to the forearm, and you can see the strap there. So this was the original prototype, and this exact photo can be found on page 6483 within the final rule that's posted on the Federal Register. So summary of change. The final rule's amended definition of the term rifle now provides that a weapon equipped with an accessory, component, or other rearward attachment giving surface area for shouldering the weapon will meet the definition of a rifle. There are relevant factors in the final rule that must be considered. The intent of the final rule is to clarify that firearms with attachments that provide surface area for shouldering indicates that it is indeed designed, made, and intended to be fired from the shoulder. So the effective date of the final rule. The final rule was signed by the Attorney General on January 13th of 2023. It was published in the Federal Register today, January 31st, which starts the 120-day countdown for all compliance obligations set out in the final rule. The deadline to comply with the Final rule statutory requirements is May 31st of 2023. So implications on classifications. So what are the implications of the final rule and amended definition of rifle now that it includes stabilizing braces? This means that all previous classifications are superseded and considered null and void as of today. Firearms with such attachments may be submitted to ATF for reclassification, which we'll get into later in the presentation. There are other alternatives available for anyone who does not wish to go through the NFA registration process, and we'll get into that in later slides.
So jumping into the amended regulatory definition of rifle, which can be found in both 27 CFR 478.11 and 27 CFR 479.11, which both define the term rifle as one, for purpose of this definition, the term designed or redesigned, made or remade, and intended to be fired from the shoulder shall include a weapon that is equipped with an accessory, component, or other rearward attachment, e.g. a stabilizing brace, that provides surface area and allows the weapon to be fired from the shoulder, provided other factors as described in paragraph 2 indicate that the weapon is designed, made, and intended to be fired from the shoulder. Second part of this is when a weapon provides surface area that allows the weapon to be fired from the shoulder, the following factors shall also be considered in determining whether the weapon is designed, made, and intended to be fired from the shoulder. 1, whether the weapon has a weight or length consistent with the weight or length of similar design rifles. 2, whether the weapon has a length of pull measured from the center of the trigger to the center of the shoulder stock or other rearward accessory, component, or attachment, including an adjustable or telescoping attachment with the ability to lock into various positions along a buffer tube, receiver extension, or other attachment method that is consistent with similar design rifles. Whether the weapon is equipped with sights or a scope with eye relief that require the weapon to be fired from the shoulder in order to be used as designed. 4, whether the surface area that allows the weapon to be fired from the shoulder is created by a buffer tube, receiver extension, or any other accessory, component, or other rearward attachment that is necessary for the cycle of operations. 5, the manufacturer's direct and indirect marketing and promotional materials indicating the intended use of the weapon. And lastly, information demonstrating the likely use of the weapon in the general community. So under subsection 1, we talk about providing surface area that allows it to be shoulder fired. And here's some examples of different types of stabilizing braces or arm braces. And when that component is there, we will then go to 2. When a weapon provides surface area that allows the weapon to be fired from the shoulder, the following factors shall be considered and determine whether the weapon is designed, made, and intended to be fired from the shoulder. And those were the 6 categories that we spoke of earlier. The weight or length. If the weight or length of the firearm is consistent with the weight or length of similar design rifles, then this would be an indicator that shoulder firing the weapon provides stabilization and is beneficial in firing the weapon, and thus that the firearm is designed and intended to be used in this way. Here we're providing photographs showing examples of that. On the top, we're comparing, or top and bottom, we're comparing apples to apples or oranges to oranges. So the top photo is showing with a arm brace or stabilizing brace, whereas in the bottom photo is showing a manufactured stock. Again, this is comparing the same type of rifle platform to one another. Again, this is the same thing here, showing the weight or length and treating them similarly. With the braces being on the top photos, both the left and right, with the manufactured stock on the bottom photos. The length of pull. The length of pull is a common measurement of firearms that describes the distance between the trigger and the center of the shoulder stock. A shoulder-fired weapon generally will have a length of pull that allows the placement of the firearm shouldering device against the shooter's shoulder, while ergonomically allowing the shooter to engage in the firearm's trigger. Adjustable or telescoping attachments that lock into will lock into place, provide horizontal support for firing from the shoulder. We're showing here that the length of pull is measured from the center of the trigger to the center of the shoulder stock, and this is how it would properly be done. Sights or scope. Sights or scopes that cannot be used without shouldering the weapon indicate the firearm is designed and intended to be fired from the shoulder. In description and photograph here showing that eye relief with a scope to where that scope would not work as designed if it was not brought to the shoulder to be shoulder fired. Some additional photos here showing rifle scope at the top photo. We're showing a red dot there with a magnifier on it. That magnifier is the key portion of that, to where you would need an eye relief placed in the eye near the scope in order to be used as designed, and the bottom picture being a thermal scope, again, needing that eye relief, bringing the firearm to the shoulder. Rearward attachment. An AR-type pistol with a standard 6 to 6.5 inch bumper tube may not be designed and intended to be fired from the shoulder, even if the bumper tube provides surface area that allows the firearm to shoulder, because it is required for the cycle of operations for that weapon. Here, the next slide is a photo showing that cutaway, showing that that buffer tube is needed for the buffer and buffer spring. As opposed to these descriptions shown here, on your AK-type platforms and HK-type platforms, where that rearward attachment is not needed for that firearm to cycle as originally designed. Marketing and intended use. The manufacturer's marketing and promotional materials for a weapon are relevant in considering the likely use of the firearm in the general community, which will be last. The actual use of the weapon, receiving information demonstrating the likely use of the weapon in the general community.
Options for the affected parties. The affected parties are the unlicensed possessors, which are your individuals, the FFL licensees that are not qualified under the NFA as manufacturers or importers, the FFLs that are qualified under the NFA as importers or manufacturers, and certain government entities. This is a tax forbearance for persons who are currently in possession of a stabilizing brace making the firearm an SBR. For individuals, FFLs, and FFL SOT dealers not qualified as importers or manufacturers under the NFA, you will have until starting today, January 31st, you will have until May 31st, 2023 to submit an E-Form 1 if you have one of these in inventory. If you are classified as an importer or manufacturer under the NFA, you will submit an E-Form 2 before May 31st, 2023. The E-Form 2 does not have a tax payment with it. It is a notification. And once these firearms are registered, all applicable transfers will require a tax payment. Options for possessors. All possessors will have the following options. And again, this is for pistols with stabilizing braces currently already possessed. This is not for building. This is for anyone that possesses one of these as of today. They will have the option to remove the short barrel and attach a 16-inch barrel. What we have to remember is that it must also meet the 26-inch overall length for a rifle under the GCA. They may permanently remove or dispose of the stabilizing brace. They may turn the firearm into their local ATF office. They can destroy the firearm, or they can register the weapon as addressed below. Registration options for non-licensees or individuals. They may submit the E-Form 1 prior to May 31st, 2023. They must currently already possess the SBR with the stabilizing brace. They will not be required to pay the $200 tax, and they may adopt the markings on the firearm. So if the firearm is marked they may adopt the markings. If the firearm is not marked, they must comply with 478.92 or 479.102. Next slide. FFLs that are not licensed as importers or manufacturers under the NFA. Again, this is for firearms that are currently in inventory, pistol with a stabilizing brace, already possessing an SBR. They may also fill out the Form 1 for anything that they have in inventory prior to May 31st, 2023. They will not be required to pay the $200 making tax. They may also adopt the markings that are on the firearm if it is marked, and if it is not marked, they must comply with 478.92 or 479.102. For FFLs that are not manufacturers or importers under the NFA, if you wish to continue to deal in SBRs with stabilizing braces, meaning that you wish to continue to obtain these into your inventory and to sell them, you would need to pay the SOT tax as an NFA dealer. However, if you only want to sell the items that you currently have in inventory that you are registering, you will not need to obtain the tax to get rid of the inventory you currently have on hand. So again, this is only if you were to want to continue down the road, you would need to pay the FFL SOT tax. If you want to continue to engage in the business of manufacturing SBRs with stabilizing braces, you would need to pay the SOT as a Class 2 NFA manufacturer. Registration options for FFL importers and manufacturers. Again, this is a notification, so there's no tax required for this. You will have until May 31st to submit the E-Form 2 for all firearms you currently have in inventory with stabilizing braces. To transfer after today's date, January 31st, 2023, the SBR must be registered in the NFRTR, and all future transfers would go on a Form 3 or a Form 4 tax paid. Government entities, when they have in their possession either making or what they've taken off the streets, they may actually complete the E-Form 10, but they are limited to transfer to other government entities only. So we are allowing the government entities to complete the E-Form 1, and there will no, for anything that they have in inventory prior to May 31st, 2023, and they will not be required to pay the making tax. Transfers after today's date must first be registered in the NFRTR, and future transfers to NFF to individuals would require a Form 4 tax paid. And anybody that makes one today or later than today would be required to complete the NFA Form 1 as a tax paid transfer. So if they did not already possess it or make it prior to today's date, that would require the NFA Form 1 tax paid transfer. Next slide. These are our resources. If you go to the first link, that is where you will find how we got here, the PowerPoint, the Q&As. Then we have our e-regs. We have the e-form address if you need to access e-forms. And then if someone needs to become an SOT dealer, that would be the link for the special occupational tax. For questions, you can send your questions to fipb@atf.gov. If you have a technical question regarding a device, you don't know what it is, you can send that to Firearms and Ammunition Technology Division. Their email address is fire_tech@atf.gov. If you have questions on the rulemaking process, you can contact ORA@atf.gov. And for anything regarding e-forms, that will go to the Ask the Expert page for NFA.
Okay, excellent. Thank you. All right, so now we're going to jump into questions. Looking at the questions that have been submitted thus far, obviously we have a lot of the same questions. So I'm going to do my best not to ask the same question over and over again, but at the same time to get the specific questions that you all are interested in answered appropriately. All right, so the first question. Will 922R apply to imported pistols equipped with stabilizing braces when registered as SBRs under the final rule during and or beyond the 120-day period?
No, 922R will not apply to that. You can go ahead and register those pistols on the Form 1. Or I'm sorry, those short-barreled rifles on a Form 1.
beforehand.
Okay, next question. To clarify my previous question, although the pistol was put into the gun trust last year, no application to register it as an SBR was made yet. In such circumstances, since the trust is now in possession, may the trust register the pistol as an SBR under the provisions of this rule?
Yes, the only person that can register this would be the trust, because the trust is the possessor of the firearm. So the trust would be the appropriate vehicle for registration of that.
Okay, next question. Will there be special instructions for the ATF Form 1 to assist in complying with the NFA registration for individuals? The current form leaves lots of room for questions and confusion and does not appear to take into consideration the unique nature of why this action is being taken.
Sorry, I'm not sure if I understand the question.
Is the person who's completing the E-Form 1, are they able to indicate on the form that their item pertains to this situation in the tax forbearance?
Yes.
Perfect. All right, next question. How will an FFL know if someone brings in an AR pistol that has the brace removed if the previous owner had submitted a Form 1 for that firearm? I think that the question is an individual registers their item as an SBR, but then at some point decides that they are going to remove it from that classification by removing the stabilizing brace. I think the question they're trying to get at is there any sort of notification to ATF once they've registered it, if they decide to remove the stabilizing brace, they need to notify ATF?
Yes, they should send a letter over to the NFA fax at atf.gov with their firearm information if they are changing the configuration of it.
And obviously, FFLs, if someone tries to bring something into your store, you certainly should contact your local ATF office if you have any concerns or questions about that particular firearm. Next question. Will this include the Kalashnikov USA Comrade shotgun, which came with a brace from the manufacturer? And if yes, can they be registered under this ruling tax-free?
So this ruling only applies to pistols. The Comrade is a firearm and is not a pistol. So this ruling itself, we redefine rifle only. However, we note in the rule itself, the publication, that any classification letter that was put out regarding arm braces is no longer valid. And we specifically refer to some of these types of weapons as now being under the purview of the NFA, as they would be deemed to be short-barreled shotguns because they possess rearward attachments that are designed to be shouldered. If you have a question about your specific firearm, you should send it in for classification. We'll take a look at it. But the change in the definition is only to rifle. It does not deal with these particular firearms. However, if you're relying on the prior classifications for these arm braces, those are no longer valid.
Okay, next question. What happens to pistols with these braces that were shipped, invoiced yesterday or the day before? Will they be returned to the FFL who shipped? So I think they're trying to get at if these firearms that are now considered short barrel rifles are currently in transit and an FFL receives them today or further on down, what are their options?
So the option number one is if you receive a package before opening it, you can always return it to sender. However, if you open it and take possession of it, you're going to be in possession of an unregistered SBR. At that point, you will not be able to send it back because that would be transferring an SBR back to the person who sent it to you. Your options then would be limited. You can't also register it because you received it after the effective date. So you would be able to put a longer barrel on it. You would be able to pull the arm brace off of it. You'd be able to destroy it, or you'd be able to turn it in. Those are your options, but you would not be able to register it tax-free on a Form 1.
And you would not be able to register it because you received it
After the effective date. You didn't possess it prior to the effective date. Exactly.
Next question. I received an AR pistol into my bound book. If I remove the brace and install a 16-inch barrel, how do I properly record the change in my bound book?
So you received it as a pistol. You're going to log it out to yourself. You're going to turn it into a rifle, log it back into yourself, and record it as a rifle. You're changing it from a pistol to a rifle.
Next question. Would you be in possession of a SPR if you had a registered pistol, pistol barrel, rifle barrel over 16 inches, and a pistol brace, or fall into the constructive possession of a SPR?
So we don't really want to get into the specifics on constructive possession because those questions are extremely fact specific. So the obvious ones are all you possess is the pistol along with the brace that you've removed and set beside it. In that situation, that would be considered constructive possession because all you've done is broken the two down. However, on the other hand, if you are an FFL and you have dozens and dozens of parts to include 7-inch barrels, 18-inch barrels, and everything in between, receivers, you've got stocks, you've got arm braces, you have all of this together. In that situation, it wouldn't necessarily be deemed to be constructive possession. So we don't really want to go into the specifics of these. Clearly, the extremes, those were the extremes as examples that I've given to you. However, if someone comes in and you pull off the arm brace, if you're an FFL and you pull off the arm brace and you sell it to them and you hand them both pieces and they walk out with that, what you've sold them is a short-barreled rifle. You've just merely removed the arm brace or the stock from it. So the specifics of those are going to be dependent on the actual facts. So we don't want to go too far down that road.
Okay, next question. Is there an objective measure for surface area that is acceptable?
The concept, or it's made clear in the rule that if there's surface area sufficient for shouldering the device, then that's it. So the question is surface area sufficient for shouldering? There's not a specific so many square inches or centimeters or something like that. It's whether or not it can be shouldered. That's the analysis. There won't be a specific dimension that's going to be given on that.
Okay, next question, and we've had several of these. Will a pawnbroker FFL be required to remove the arm brace from currently pawned items? So we've gotten this question in a lot of different variations. People asking about, I'm an FFL and I have stuff on layaway. I'm a gunsmith and I have these items in inventory, and then the pawn shop question. So as of today, the rule is now effective, and so it's what you are currently in possession of. It does not matter why you're in possession of that item, so it doesn't matter if it was pawned, if it's layaway, if it's gunsmithing. If you are currently in possession of it, you are an FFL that does not have a manufacturer importer SOT. Your options are to remove the brace, attach a 16-inch rifled barrel, turn it into ATF, destroy the firearm, or register the firearm. Obviously, if these are other people's firearms and you have them for some reason, we would encourage you to discuss that with the owner of the firearm, but you cannot give it back to them in their current configuration. So removing the brace, and then you can give them back the item, or you can add a 16-inch barrel. The next part of that question was, can I return the brace to the pledger upon redemption? So again, this goes into the constructive possession. You do not want to hand back to the customer both the firearm and the brace in the same transaction or in a structured transaction. So you will need to work with the individual on that. If you have more specific scenarios, you can submit those. Next question. An 07 Type 02 assembles a personal AR pistol that is now considered an SBR. Can I submit as an SBR on Form 1 without marking exempt from SOT, or would it be better to transfer it to my 0702 for use as a demo? So there's a lot of parts to this question. I think the individual is asking, as an FFL, can I assemble a personal AR pistol that is now considered an SBR? Well, the rule is effective today, so anything that you would make beginning today would fall under the regular NFA requirements. So it would be a Form 1 with the tax requirement in there, the making tax of $200. The tax forbearance only applies to items that you are currently in possession of that meet this definition. Next question, if someone submitted a tax exempt Form 1 prior to today, are they in the queue or will they get denied?
They're in the queue.
Great. Next question, can we sell someone with a SBA on it today? Does this rule go into effect at 12:01 a.m. on February 1st, 2023? When does the rule go into effect?
It went into effect this morning at 12:01. It was published, so it is effective today. It is not effective tomorrow. It is effective today.
Yes. And the rule says so.
Okay, so again, to be clear, the rule was effective upon its publishing in the Federal Register, which happened at 12:01 a.m. today. Correct. Next question, if we have them in our store and someone wants to buy it today, what is the requirement? So again, you cannot, now the rule is effective. You cannot transfer it to them in the current configuration that makes it a short barrel rifle. So your options to sell it right now to an individual would be to remove the brace and then you can sell it, or add a 16-inch rifled barrel. All right, next question. I have a pistol with brace and inventory purchased a few months ago. It has not been altered. Can I sell as a pistol until May 2023? Let's answer that first question. So I have a pistol with a brace and inventory purchased a few months ago. It has not been altered. Can I sell it as a pistol until May of 2023?
Not with the brace.
Right. So again, your options are going to be, you cannot sell it in its current configuration because its current configuration makes it a short barrel rifle. So you would have to remove the brace in order to sell it as a pistol. Question number 2 of that, must I convert status to SBR using the free stamp, and a buyer will be required to pay an additional transfer tax? So yes, the tax forbearance applies to current possessors. So if you are currently in possession of a pistol with a attached stabilizing brace that makes it an SBR, you will need to go ahead and register that firearm. And then once it's registered, you can further transfer it, but it will be subject to the NFA tax. Okay, next question. Can you clarify the 88-day rule?
The 88-day rule is not a rule from ATF. That is something that's within the background checks for the FBI. I do want to note that ATF as well as FBI and NICS were working together to develop a more efficient solution for applicants that are looking to result in an open background check that's in a delayed status. Again, it's a priority for both the agencies, and we are trying to have an option for these folks.
Next question. What are the rules for exporting braces?
So that's not going to be an ATF question because we don't deal with the exportation of components and parts for firearms. I believe you're going to have to check with either Commerce or Department of State. I believe it's Commerce, but ATF, we're not in a position to answer those questions for them.
Okay, next question. What is the minimum length of pole that will qualify as a rifle?
So we don't have a minimum length of pull established. We did provide a chart in the final rule, but what we will do is compare apples to apples. For example, a Glock and a Roni kit with a stabilizing brace will be compared to a Glock and a Roni kit with a known shoulder stock, whereas an AR will be compared to another AR of similar size and design.
Okay, next question. How does the ruling affect registered AOWs that are equipped with a stabilizing brace?
So if they meet the criteria of short barrel rifle based on the final rule, they will need corrected in the NFR-TR to the correct classification.
Okay, next question. So an AR with just a buffer tube is now an SBR.
Negative. The AR with the buffer tube is clearly defined. If you go to Section 2, Part 4, we're talking that buffer tube we understand is needed for the cycle of operations. So that rearward attachment is necessary for that firearm to perform as it was designed and to function properly. So we're saying the buffer tube, we understand being there. You may be able to put that as surface area and shoulder fire. We'll understand it's needed for the cycle of operations, as opposed to other firearm types that don't need any rearward attachment, where there was different braces that were attached to it.
Okay, next question. If a person has a brace that a Glock pistol can be inserted into, like a CAA, RONI, or MCX, and they own multiple Glock pistols that can be inserted into the RONI, should they register each combination to prevent being in constructive possession?
No, the only one that would need registered, it would be if there is one currently in that RONI kit, and that would be the Glock pistol that would get registered because it was the one that meets the definition of short barrel rifle under the final rule, not every additional Glock pistol.
Okay, next question. Isn't a tax forbearance just a delay in tax that will need or could be made to be paid in the future?
So that's a really good question. In this situation, we are refraining from collecting the tax. That's the use of the word. So the tax is currently owed on these. We are not collecting that tax. This rule is something that you can rely upon. It is not something that is going to be collected in the future. No.
Okay, next question. So a pistol tube with the foam sleeve is okay to have?
We understand that we're not saying all foam tubes that are put on there, but the one that was originally designed was for cheek firing, which we understand. Again, that's not something we're looking at as, intended to be fired from the shoulder that provides surface area to meet one of those other factoring criteria. We understand that's there for a cheek fire. That's for that piece of foam, not any type of foam that's put on there.
And obviously, if they have specific questions about their firearm, they can send the questions to fire_tech@atf.gov.
Correct.
Okay, next question. We have lots of state-related questions, so we'll try and just give you an answer as it applies to all state laws. The question is, are we still able to sell pistol grip firearms with a 16-inch barrel in Connecticut? If you could answer that and then also talk about the state laws.
So we're not going to answer that specifically to Connecticut because that depends on Connecticut state law, and ATF can't opine on state laws. We understand that there have been some conflicts that have arisen that the states do not allow the registration of a short-barreled rifle. In those situations, NFA branch would be unable to approve an application to register if the state does not permit it, because under the law, ATF will not register a short-barreled rifle to you if it puts you in violation of state law. But as far as the specific questions about each individual state, you're going to need to reach out to the Attorney General, and that's for that state, and ask them for clarifications.
Okay, next question. I understand that manufacturer's marks can be adopted. There seems to be confusion on the maker's mark engraving requirement. Found in box 4H of the Form 1, it specifies to state how maker's mark will appear on the firearm. Is this requirement being waived? So it's asking, do I have to mark my firearm?
You do not have to mark it. You will use the markings that are already on the firearm. So no additional markings will need to be placed on it. And you will put down that information as the manufacturer on the Form 1.
So the markings that are on the firearm currently is what you're going to put down. So whatever it says the manufacturer was, that's what you're reporting on the E-Form 1.
Correct.
Okay, next question. So is it illegal to possess a stabilizing brace from this ruling that is not attached to a firearm?
The simple answer is no. ATF doesn't regulate parts. There's always a question of constructive possession. If you've separated it from a AR pistol and you have them laying side by side and that's all you have, then that would be constructive possession of an SBR. But no, the braces themselves are merely parts. There's no regulation of the braces.
Okay, next question. What is being done to the eForms website to handle the volume? We have been unable to consistently log into and process forms properly due to website malfunctions.
Recently, we've been doing some testing and updating of systems so that it can handle the load of people that are accessing the system right now. So unfortunately, you may have been caught up in that last week. It is operational, fully operational at this point.
Thank you. Okay, similar question to what we had a little while ago about pawn shops. It says, are we prohibited from transferring any firearm that falls under this new ruling as of today, or do we have 120 days to get them back to the pledgee? So to be totally clear, so everyone's on the same page here, current possessors of these have those 5 options to get into compliance. Those 5 options have to be, one of those 5 options has to be taken by the 120 days, which is May 31st. So if you are a pawn shop and you have these items in your possession, so a pistol with a stabilizing brace attached that now is considered a short barrel rifle, you cannot give it back. You cannot transfer it, whether you're giving it back to the person that pawned it or anyone else. You cannot transfer that firearm in that current configuration because that would be considered transferring an unregistered NFA item. So you have the options that we laid out in the PowerPoint. You can remove the brace. You can attach a 16-inch rifle barrel. You can turn it in. You can destroy the firearm. Obviously, you do have the option that you can register it. I know that is not going to be probably an option for you as a pawn shop. So again, you cannot give it back to the individual in its current configuration. You have to have it in compliance within 120 days. Next question. Do you have any examples of firearms with braces that are not considered SBRs under this rule?
Yeah, FATD has seen some of these. Unfortunately, they haven't been marketed simply because they lack the rear surface area to be good for shouldering the weapon. So there are a few examples. The Federal Register does have at least one, if not 2 examples of some of the things we've seen that would not qualify as SBRs under the new rule.
And then you guys do have a guidance document on the website, on the public website, that provides examples of items that are considered SBRs, correct?
Yes, ma'am.
Okay, next question. Can paper forms be filed or only through the e-forms to register?
Either. We prefer electronic.
Okay, next question. I am a class 3 dealer. If I have a pistol with brace, do I simply move them into my NFA acquisition book?
I'm sorry, can you repeat it?
Yep, I'm a class 3 dealer. I think they're saying I'm an FFL SOT dealer. If I have a pistol with brace, do I simply move them into my NFA acquisition book?
They would have to still do the Form 1. You have to do a Form 1, and they should already be in your book, but you are going to need to change it from a pistol to an SBR, logging it out to yourself, logging it back in as an SBR, but you do need to do the Form 1 to register it.
Thank you. On the responsible persons form, is the individual person / trust the manufacturer, or is it the manufacturer stamped on the firearm, the manufacturer, since we are converting it? So again, this is the markings that are already on the firearm. So this is what we talked about before, is that you can adopt all of the markings that are already on that firearm. So no, you do not need to put your name or the name of your trust as the maker. Okay. Okay, next question. What about AFMR on pistols for FFL SOT holders? Are we responsible for that?
It's more of a teaching question, isn't it?
Yeah, that's actually a great question. We're going to research that, and we will add it to our frequently asked questions. So the question again was, what about AFMR on pistols for FFL SOT holders? Are we responsible for that? So thank you for that question. We will add it to our frequently asked questions, which are on our website. Next question. Does the ATF have the legal right to waive a tax?
Yes.
Okay, next question. Although it was not stated verbally during the presentation, the slide said the brace should be permanently removed, but I thought I saw that it has to be destroyed or make it unable to reinstall. Must it be destroyed?
No, the brace is like any other firearm part. In and of itself does not make an NFA weapon. We've talked a little bit about constructive possession. That's where the alter comes into place. If you want to remove a brace that uses a mil-spec extension with adjustability notches, you could replace it with a round tube, but that is not necessary. You can just basically remove that from your immediate possession. In other words, do not remove the brace and store the firearm in a dresser drawer with the brace in the same dresser drawer. That would still constitute constructive possession, where you essentially have the same short barrel rifle.
Okay, next question. As a Type 01 FFL with a Class 3 SOT, so a dealer SOT, I think this is what they're asking, do we have to form all of our firearms with braces on it? So if you are an FFL and you have a Class 3 dealer SOT, if you choose to register those firearms, you would be doing it on an E-Form 1. But that is not your only option. So remember, you have 5 options as well. Remove the stabilizing brace, attach a 16-inch rifled barrel, destroy the firearm, turn it in, or register it. And so again, FFL, SOT dealer, you would be registering on an E-Form 1. Next question, will SOT applications be expedited?
No, we process them within 30 days.
Okay, next question. Will foldable stocks on AK-47s need to be removed, destroyed, and or registered?
Are we talking, if we're talking about folding braces, again, we would take all the criteria into consideration, holistic, the weapon as a complete package, but stocks would already have made the weapon an SPR.
Okay, next question. Are we losing the category of pistol grip firearm?
So this particular regulation only defines rifle, and that's talking about the application or the addition of an arm brace to what was people said were pistols, which means it's rifled bore. We make it clear that it's only to rifles. However, we put in the rule, as you can see, that any classification that was previously done where a brace was added to the pistol grip, firearms, those that are colloquially known as a pistol grip shotgun. That's the way the industry puts these out. That any of those are no longer valid. We have rescinded any classification where you've attached an arm brace to what's known as a pistol grip shotgun. These are these firearms, the Persuaders, I think, the Shockwave, those types of firearms. So this rule doesn't apply or doesn't redefine short-barreled shotguns. It only applies to rifles. However, we have made it clear that any of those classifications are no longer valid. So if you have one of those where you have added an arm brace, you could send it for classification. If it provides surface area that you're going to use to shoulder, because these were never intended to be fired with one hand, and we make that clear in the rule itself, then chances are it's going to be a short-barreled shotgun. That's sort of a general statement on those, but if you want a specific classification, you can get that by sending it in.
Okay, next question. What about the micro conversion kit? Can we sell them, and do we have to tell the customer they have to register it, or do we have to?
No, it's an accessory or a part. You don't have to, I mean, you can continue to sell it. It'd be no different than selling a 7.5-inch barrel as opposed to a 16-inch barrel in the same shop. It's up to the end user what they do with that possession of that, and that would be on them to register it properly.
And whether or not you're required to advise them of it is a question for your lawyer and under probably under state law as well as anything to make a determination of whether or not you owe a duty to the person you're selling it to notify them that. But that's not something we would comment on.
Okay, next question. Will the presentation slides be made available? Yes, they are already available. You can go to our website, atf.gov. You can type in the search bar stabilizing brace, and it will bring you to the page that has this PowerPoint as well as numerous other documents to help explain this to you. It's also been posted in the chat. The actual link is there, and it's being shown right now on the PowerPoint. Is that very first bullet. That is the exact web address to get to this PowerPoint. Okay, next question. If an individual has multiple braces in this example, say it's 5, can they register all 5 and avoid the $200 tax-free?
If it is associated with or attached to a particular firearm. Remember, you're only registering, someone can only get a tax-exempt registration on a firearm equipped with a stabilizing brace. So if you have 30 receivers in one brace, you're not entitled to register 30 receivers tax-free. it would be the firearm that the brace is associated with or attached to, then you can register that one and that one only. You make that, you confirm that under penalties of perjury when you file this application for tax-free registration. But if you have multiple firearms equipped with stabilizing braces, there's no limit as to what you can register.
Okay, next question. Once registered as an SBR, may I legally change the pistol brace to a rifle stock?
Yes, we're stating that this is a surface area provided for shoulder firing. So no matter if it's a brace or a manufactured stock, once you receive that notification from us, then yes, by all means, you can put any shouldering device that you'd like to on the firearm and keep it within that purview of the NFA as an SBR.
Okay, next question. On Form 1, I can adopt markings. Can I adopt the markings if filing a Form 2? Yes, you can. Right. How long will stamp approval take? So obviously they're asking how long. Let's talk about E-Form 1 first.
It depends on the amount of submissions that we receive.
And the E-Form 2?
30 days.
Great, thank you. Okay, next question. How should FFLs operate when a customer brings an AR pistol to purchase components compatible with their firearm? Is FFL responsible for the individual's firearm, even if the firearm is not staying or getting checked in the FFL's A&D book? I think what they're trying to ask is if someone brings in an AR pistol and wants to buy the components to essentially attach a stabilizing brace or some sort of stock to it, does the FFL have any responsibility here?
So if you are assisting or aiding and abetting the assembly of an unregistered SBR, clearly there could be some liability with that. But if you're merely selling parts to someone, you're entitled to sell parts. There's no requirement on that. But again, you can't aid and abet the manufacturing or making of an SBR that's unregistered. There's too many nuances to that question. It's too fact specific. If you have specific facts about that, you should consult with an attorney to make a determination of whether or not what you are doing is lawful.
Okay, next question. I have an 01 FFL. I was planning on applying for my 03 SOT, so dealer SOT, but was told I could not get one until July 1st, 2023. This would leave my FFL without the 03 SOT for a month and a day. Is the ATF doing something about the start date for 03 SOTs for this year only?
No.
So can you talk about the SOT period?
So the SOT period runs from July 1st to June 30th. If you pay now, it's only going to be good for another, 3 months. So you're only going to benefit for 3 months. But again, we can't adjust the tax period and it is not prorated. It runs from July 1st to June 30th.
Yeah, so that might have been what was going on. It's not prorated, so you would have to pay the full amount for the SOT, even though you would not get to use that SOT for a full year, right? Because the SOT has to be renewed annually, not every 3 years like the dealer FFL. Okay, next question. Are fingerprint cards and pictures required for all of the SBR filings?
Yes.
Okay, next question, and you guys might need more information, but I'm going to ask it. What would a Keltec CMR 30 be defined as?
Well, it depends if it has a attached brace. It has a little bit of rear surface, but without an attached brace, it's just a standard handgun.
Okay, next question. If the pistol was already submitted for transfer, but person hasn't gotten a proceed from the police department, are they too late to submit a Form 1? So again, this goes back to who's currently in possession of the item. Regardless of why they are currently in possession of it, the rule was effective today at 12:01 a.m. So if you as the FFL are in possession of a pistol with a stabilizing brace that is now considered an SBR, you cannot transfer it in that current configuration. So you would need to work with the customer. You have the same 5 options that we've gone over multiple times, but you cannot transfer that current configuration. When you talk about submitting the Form 1, you as the possessor are the person that would submit that Form 1. It is not that individual customer. Next question. Can FFLs assist with the completion of the Form 1s with the customer? If the customer completes a Form 1 in the shop under their personal eForms account, are they allowed any assistance?
Yes, you can certainly assist someone in doing it. You can't do it for them. You can't do it for them and say, and submit it on their behalf. They must do it, but you can help them with it.
Okay, next question.
Can I jump in? So back to the Kel-Tec CMR 30, that is sold as a rifle. I confused that with the CP 33, which is what I thought the question was addressing, because CP 33 has about 2 inches of rearward surface. We would not consider the CP 33 affected by the final rule.
Okay, next question. If our FFL is also a gun range, how do we go about customers coming in with pistol braces after the 120 days? So again, if someone is bringing in their own firearm, unless you have reason to believe that they are illegally in possession of that firearm, there is nothing for you to do because you're not the possessor of that firearm. Okay, next question. After registration and approval of an SBR via Form 1 under the 120-day period, is it acceptable to remove the pistol brace and replace with a rifle stock post-approval?
Yes, that was answered there previously. We're looking at it as a shouldering device,
SBR is an SBR.
Okay, what if you just have a receiver with a brace but no barrel?
Then it doesn't fall under the purview of the final rule. This covers rifles. That receiver with a stabilizing brace attached could be attached with a 10-inch barrel. It could be attached with a 16-inch rifle barrel, or it could be attached with an 18-inch smoothbore barrel and not even be a rifle. It could fall under the definition of shotgun.
Okay, next question. Which form do I use to take advantage of the tax-free? So again, for the pistols with a stabilizing brace that under the final rule are now considered a short barrel rifle, for those firearms, you can use the eForm 1 if you are an unlicensed person or you are an FFL without a manufacturer importer SOT, it's the Form 1. For FFLs with a manufacturer importer SOT, it is the Form 2. That is only to register these current items.
If you log into your eForms account and attempt to, or do this on an eForm 1, you will see that it's been updated to allow you to specifically state that this is under the 120 days forbearance period, and you do it that way. So it is already set up. That is an option on the screen.
And it is only for these items that meet this criteria currently in your possession. This is not all short barrel rifles. This is only these specific items. Okay, next question. By changing the barrel to 16 inches, are we manufacturing at that point as a non-manufacturing FFL? Would that open us up to liability? We are offering that as one of the 5 options to get into compliance. So again, this specifically pertains to this item and this 120-day period.
Right. You're not engaged in the business of manufacturing. What you're doing is converting those firearms under this regulation, and it allows for the selling of those. So you would not be engaged in the business. You would not need a manufacturing license.
Okay, if I am filing multiple Form 1s with non-electronic prints, do I need to provide multiple fingerprint cards?
Yes. 1 second.
Okay, next question. The Brownells BRN 180 is an AR type upper that doesn't have to have a buffer tube to function, but can fit on standard AR lowers. If a folding brace is attached, can it still be registered as a SBR since it doesn't have to have the buffer tube for operation?
Right. Certain AR platform variants do not need a rear extension buffer tube. But yes, if it meets the definition with that folding device that when extended falls under the purview of the final rule, then it can be registered as a short barrel rifle.
Okay. Next question. Can an individual pin and weld a silencer to an AR brace pistol to a length of 16 inches to make it compliant?
Yes, if you permanently attach it with pin and weld and it puts that over the 16 inches, then the answer to that is yes. And keep it within the provisions of a rifle, a GCA rifle, and have your NFA firearm as far as the silencer is concerned.
Okay, next question. What about caliber markings? If the lower says multi, do we need to have the caliber engraved or just list the caliber as what's on the barrel, I think is what that's trying to say.
The NFA does not accept multi-caliber. So it has to have a caliber.
And if it's just a lower with the brace,
So if you have a 223 upper on it, you would list as 223. In the notes, you would say that there's multiple calibers, sort of letting NFA know that, but you would not need to engrave the firearm further.
and to be clear, if they have a lower with just a lower with the brace attached,
You would not be able to register it under this this forbearance period of 120 days. What you could do, of course, is you could file your Form 1, pay your $200. Once you get an approved tax stamp, then you could build your firearm.
again, to be clear, this is for pistols with stabilizing braces that meet the definition under this final rule as a stabilizing brace that you, or as a short barrel rifle, sorry, that you are currently in possession of. I submitted a form and received further research. How do I get the cover letter for said firearm with the further research for fingerprint submission?
You mean pending research?
Is that someone who should submit a question via email or?
If it's pending research, what I think what they mean is they will receive an email with the cover sheet that includes the submitted firearm, the Clio copy that they need to submit to their Clio, and a copy of their cover letter at which time that they would submit the fingerprint cards.
Is that a question if they have something else to ask about? Is that an ask the experts
Yes.
question? Okay, this is another state question. I know we've answered this, but we're going to do one more, so we're make sure everybody's getting their questions answered. In California, where we are not allowed to Form 1 or Form 4 federally, other than to remove the pistol brace, what do we tell our customers who originally registered their AR pistol with a round pistol buffer tube, with or without foam, as a single-shot pistol in the CA-DROS system? Are there any other options other than removing the arm brace back to a pistol buffer tube, and how does that state registration apply federally?
So we would not be able to register a Form 1 if state law does not permit it. So if your application puts you in violation of state law, then we would deny that application. So then you can look at, for purposes of complying with ATS, new regulation, you would have one of the other options. Whether or not those options are available to you, you're going to have to check with Cal DOJ to see whether or not it is permissible under their laws. We can't comment on California laws. As you well know, living in California, there are a lot of them, and we wouldn't want to venture down that road. So you need to check with them as far as other options are concerned.
Okay, next question. How can an individual with a homemade unmarked pistol register their weapon? So if someone manufactured their own pistol and it has an attached stabilizing brace and now they're going to register it, they would have to mark it. In that instance, they would be required because that firearm doesn't have any markings, and that's always been the case with any Form 1 submission. It is not specific to just this final rule. If anyone makes an NFA item under that Form 1, they are required to mark it. Next question. I own a Cerakoting business. What am I required to do if someone brings me an SBR to be Cerakoted? If you are performing that action as a gunsmith, meaning you are doing it on the customer's firearm and giving it back to the customer, that is allowed, again, as long as that firearm is properly registered with the individual. Next question, do we need to weigh every AR pistol now when it comes in, and how do we determine the appropriate weights Since buffers themselves can range from 2 ounces to 11 ounces, what is the weight tolerance?
As far as the weight, that's the second part of the criteria. You first have to meet the first part of the criteria, which does the firearm that you're speaking of provide surface area to be shoulder fired? If it does, then we would move into one of the other 6 categories there, but it would have to have an area to be shoulder fired to begin with.
Okay, next question. If someone comes into our FFL, do we have the right to ask if the firearm is registered or not, so we don't get in trouble for not reporting if it's unregistered? So if someone brings something into your store that is a short barrel rifle, first of all, you can't take possession of it unless it's for gunsmithing purposes. And then obviously, if you are going to be taking possession of that firearm for gunsmithing purposes, you would need to verify that it is a properly registered. Otherwise, you'd be in possession of an unregistered firearm. Obviously, if you have a situation like that, please contact your local ATF office and they can assist you. Are there any exemptions for owners who only use the brace for its intended purpose, owners with disabilities?
No, there's no exemption under the National Firearms Act for a person with a disability. If you have a firearm that is configured as a short-barreled rifle, it has to be registered. That's true for all NFA firearms, be they silencers, machine guns, short-barreled rifles, short-barreled shotguns. So there's some confusion created with when people, I think more in the reporting of this. If some of the original designs that were submitted, and you can see those in the final rule, that were not designed and intended to be fired from the shoulder, those may qualify, and those were originally designed or purported to be for people with disabilities. But those didn't qualify as short-barreled rifles. So if it doesn't qualify as a short-barreled rifle, then you don't have to register it. If it qualifies as a short-barreled rifle, regardless of whether or not you have a disability, it must be registered. You can do it, of course, in the 120-day period in order to do it tax-free.
All right, and the last 2 questions we have concern trust. So number 1, can a trust submit a Form 1?
Yes, if the trust is the current possessor as of the effective date, which is today, if the trust possessed the firearm prior to the effective date, the trust would be the only person who can submit the Form 1 and have it registered. What cannot occur is a person can't decide that the trust is going to be the one to file the application and then transfer it to the trust and then have the trust file the paperwork, because that transfer is unlawful because it is a short-barreled rifle that's not currently possessed by the trust. If the trust is going to register this firearm, we do require that the trust show evidence that it possessed the firearm prior to the effective date.
And then, sorry, just to add on that, I know you've said it multiple times, but is there any documentation required to be submitted to prove that the trust owns the firearm?
Yes, typically it is a Schedule A. That's the typical way. Trusts are governed by state law, but typically a trust has like a Schedule A that has a list of the property. You would need to show that Schedule A that's properly dated, showing the date on which it was added to the trust. And that has to be submitted because you have to show that the trust possessed the item for the trust to register that firearm.
Okay, and lastly, I saw there's a few questions in there, looks like from FFLs, asking if they can send their inventory back to the manufacturer, so meaning that these items, pistols with a stabilizing brace that now are considered a short barrel rifle, can they send them back to the manufacturer? No, you cannot transfer the item in its current configuration because as of today, the effective date of the rule, it would be considered transferring an unregistered NFA item. So that is not one of the 5 options. So FFLs, unlicensed possessors, and our FFL manufacturer importer SOT holders, please refer in the PowerPoint to the 5 options. Those are the only options. Cannot state it any more clearly that you cannot transfer that item to anyone outside of turning it into ATF for any reason other than one of those 5 options.
And the key phrase there is current configuration. Some manufacturers are willing to take their firearms back once the brace has been removed and it can be transferred as a pistol.
And then lastly, a question about military It says, I have a lot of customers who are military members, many who are deployed for greater than 120 days. As such, they will be unable to properly complete a Form 1 while deployed. What is the process for these individuals who return home and are now violating NFA? So again, if they have the ability, they can, if they have internet, they can submit an E-Form 1. If they are unable to do that, certainly when they return home, they will have the other options, which is to remove the stabilizing brace or attach the 16-inch rifle barrel or to turn it into ATF. So again, those are your options within the 120 days. All right, that is all of the questions. Again, we are going to be hosting the same training tomorrow at 10 a.m. Eastern and at 2 p.m. Eastern. It is the exact same training, but if you would like to attend again, you are more than welcome to. It is a different link for tomorrow's session. So